Welcome to Looking at Legal Stuff. Today we have 8 hearings in a case with a couple where Dad has petitioned the court for a temporary restraining order because he says Mom's been neglectful and isn't making sure the child attends school properly. He says this is due to Mom's chaotic lifestyle and heavy drug use. Mom says that's not true and she doesn't know why Dad is accusing her of these things after many years of peaceful co-parenting. She attempts to disprove Dad's claims by providing the court with a clean UA, even though no test had yet been ordered by the court. But Dad pushes the court for a hair follicle test rather than just a UA. What will Mom's hair follicle test show? Let's find out.
All right, best of luck. And then that does take me, I believe, to my last case on the docket. I have Mr. Denlocker and I have Ms. Is it LaCour?
Yes.
Okay. So I did review this file previously, and we've got a lot going on here, and we have a lot that is scheduled for future days. So I know you both are unrepresented, so I'm first just going to tell you what is properly before the court today and what is set for future dates. So today, what has been set on, I know that, and let me just see, I'm not sure if Mr. Denlocker is with us. Mr. Denlocker on the iPad, are you with us?
I don't know why it keeps going to mute.
Okay.
Sorry about that.
And then somehow the camera's on the ceiling. There, we can see you now. Okay.
Good morning.
Good morning. So what actually is set for today is a review of the restraining order request from petitioner. What is set for future dates is essentially everything else, but Ms. LaCour has filed her own request for temporary orders and a restraining order. That has been noted on for our January 3rd docket. Mr. Denlocker, I see that you have also filed proposed parenting plans, or a proposed parenting plan, but I don't see that you actually noted those on for any specific date. The only thing that's been noted on officially and served on Ms. LaCour is the restraining order request. So the immediate restraining order and hearing notice was served on her November 22nd. So that's all that I'm able to move forward on today.
What needs to happen for the proposed parenting plan to be in place?
Yeah, so much like you may have received from Ms. LaCour, there is actually a note for motion docket for the court to review the your proposal, your request for temporary orders.
Sure.
So that actually hasn't been docketed yet. The only thing you actually docketed was the show cause order for the restraining order.
How do I go about that?
So if you come into our Superior Court Clerk's office, there is a form, and you'll see Ms. LaCour filed it. It's called a family law calendar notice. I don't know.
He could have received that on Monday. He was served with the papers.
Yeah, that's not what we're talking about right now.
Oh, okay.
We're talking about him filing his own if he wants to get his orders on the docket.
Oh, okay.
So it's called a family law calendar notice.
Okay.
Okay. So Ms. LaCour, what I won't be doing today is reviewing your temporary orders or his temporary orders or your request for the restraining order. The only thing in front of me today is his request for a restraining order. So I'm just going to start with that. Mr. Denlocker, are you requesting that this court keep a restraining order in place?
Yes,
Restraining Ms. Lucor from contact with the minor child?
yes, Your Honor. And I do have a question.
Well, just a second. I'll get there in a second. I received the original request for the restraining order. Ms. Lucor, I have received your response to it. But just today I received a bench copy of a declaration of Ryan Denlocker in support of the restraining order. It includes text messages, or I don't know if these are social media messages or text messages.
Email.
Oh, email from an Ellen Jordan. And then it also includes some Lexington Elementary School attendance records. And then it also includes Mr. Denlocker's, it looks like UAs. Ms. Lucor, have you received this information?
No.
Mr. Denlocker, did you serve this information on her?
I did. I've gone through Heather's paperwork that she served me with at 10 o'clock night before last. In the paperwork, she checked the box that she could be served via email. I emailed her those papers last night. I don't know how else to reach her because she's not often home.
So I guess let's start with this. Well, service, whether it's in person or by email, 24 hours before a hearing or less would not be sufficient for me to consider the evidence. But Ms. Lucor, are you in agreement to receive service in this case via email?
I would prefer it be in person just so that I could confirm that I had it. I can look it over on my email. I didn't get any alerts saying that I had an email from him, but it very well, he never emails me, so it very well could have went to a different folder or something. I'm not 100% sure. So I would prefer to have it in person though.
Okay, so here would be my proposal today, because I do think that there's additional information in this packet as it pertains to the restraining order that Ms. Lucor, has the right to respond to before I decide on a lengthier restraining order or not. So my proposal would be, so Mr. Denlocker, number one, going forward, it sounds like personal service needs to be made, not email. But for purposes of this restraining order motion, Ms. Lucor, will assume, if you do have it in your email, we'll assume that that has been served on you. And what if I give you a few days to respond to it? And we'll have you all back next Wednesday at 9 a.m. on his motion for his restraining order. That gives you time to look through his materials and respond.
Okay. So would she stay with him then that whole time?
Yeah, what I would do is just for the 1 week, I would just reissue the temporary order. So I'm not making any ruling on a permanent restraining order. It's just that ex parte temporary order that would be extended through next Wednesday at 9 a.m. to give you time to formulate your testimony in objection to it.
Okay. Is it being considered that as far as child support and everything, I'm listed as the custodial parent? I know that we don't have a parenting plan in this case already set, but we already have everything with child support already set up through the state. I received TANF and I was listed as the custodial parent, and he completely cut off contact between me and my daughter when I was in Tennessee when my grandma was dying. And that was the only reason I was in Tennessee for those 5 days. And that was when he decided for the first time her entire life to keep her from me. And that was when he filed, was I think November 20th originally.
Yeah, and I did see that in your responsive documents. And what I'll say, just two things. Number one, your request for temporary orders and your own restraining order is on docket for January 3rd. So that's when those questions would be addressed.
Okay.
All I'm doing today is setting over his restraining order request to next Wednesday. Look through his materials and file any responses you want to it. It does include school attendance documents and some allegations of substance abuse on your end. Whatever you can provide to the court in response will be helpful when we're back here on Wednesday.
Okay.
Okay. Anything else from the parties right now?
So in my restraining order, I thought that I had added comments that there was things to be fulfilled by the court for court order.
Let's see. What do you mean by that? You need to be a little more specific.
I asked if she could provide a hair follicle test and amongst other things, to have the restraining order in place for today.
Let me look. You did request those. Let me see what the judge signed. The judge did not. The judge who reviewed this ex parte did not include those items in the temporary ex parte order. That is very common. We typically wouldn't require those things unless we're approving an order after a full hearing.
I see.
So those are your requests, and we will deal with that next week when I decide whether to reissue this to issue a restraining order that is no longer temporary in nature. But that will be based on the evidence that's presented to me before next Wednesday or at the time of testimony next Wednesday. So typically how I handle these is you both will file your written documentation. Mr. Denlocker, you've already done that. I'm giving Ms. Lucor time to file additional documents in response to your documents. Then we'll come back Wednesday. I'll swear you both in. You'll have a chance to actually give testimony under penalty of perjury about your request, sir, and ma'am, your objection. And then I'll make a ruling about whether more likely than not, I believe a restraining order is necessary.
Thank you.
Okay.
May I ask a question?
Sure.
As far as the restraining order goes, am I allowed to contact her school as far as the attendance records?
Let's see, what did they? Let me just look at the temporary order. Hold tight. It's just, you can't go on right now until we just go to a full hearing. Temporarily, you cannot go onto the grounds of the school or enter the school. You can't be within 1,000 feet of the school, but that is it. So there is no prohibition on you contacting the school by phone.
Okay.
Okay.
You also, this is to Heather.
Well, hold on. No. Everything in the hearings needs to be directed to me.
Oh, I'm sorry. Your Honor, she will see in the paperwork that I sent her, all the school attendance and everything is all attached.
Yeah. So, I did receive those documents. So the attendance records, ma'am, are in there. So you can look through those, but there's nothing that precludes you from calling to clarify.
Sure.
Okay. Well, thank you.
And also, if I do set up a drug test or hair follicle test prior to next Wednesday, all of that is put into consideration when it comes to the restraining order. It just won't be looked at until Wednesday.
Correct. Just make sure it's submitted to the court and served on Mr. Denlocker.
Okay.
Okay. Okay. Well, thank you both. We'll see you back Wednesday, just next Wednesday. What is that? December 20th? At 9 a.m.
Okay. And it's the same docket.
Same docket. The link will be family law self-represented 9 a.m.
Okay. Thank you.
All right. Thank you both. All right. I have on 233 00494008. I have Ryan Denlocker and Heather Lucor. I'm just gonna,
Morning.
good morning. I'm gonna open
Morning.
this file here. My understanding is both of you, tell me if I'm wrong, but I think both of you have filed for restraining orders.
Yes, Your Honor.
The restraining order that I filed is not a no contact restraining order. I think that's the main difference. It was more, just don't harass, and it was the two other parts of the restraining order minus the no contact, because I don't want my daughter to not have contact with her dad.
Okay.
Have co-parented for 6 years, no problem.
Understood. And then ultimately, on January 3rd, I believe you all have on the docket temporary family law orders you're asking the court to consider.
Correct.
So I'm just making sure I don't have this wrong, because the notes on my docket relate just to the restraining order requests today. And then February 3rd, you'll be addressing the temporary parenting plan proposal. Does that sound correct to you all?
Yes.
Yes, and I also sent out a motion for January 24th.
Okay, what is that motion for? I don't think
It's actually for the temporary parenting plan. I believe I sent you bench copies.
just, let me get into my bench copy list here.
May I mention something too whenever you have a second?
Yeah, just a second. Okay, we did I do see that January 4th, 2024 is your request for the temporary parenting plan. And then January 3rd is Ms. Lucor's proposed parenting plan. Ideally, we'd want to combine those. Let's just start with that. Give me a second. I've been standing this whole docket. I'm going to sit down for a second. Rather than bifurcating on the 3rd and the 24th, I'm sure the judicial officer would be appreciative that they would be deciding the temporary parenting plan at one hearing, taking into account both of your proposals. Would you guys have an agreed date that you would want to do that? And we could make a note that, both of those are done on January 3rd, but Ms. Lucor, I don't know if essentially you'd kind of be waiving that 21 days notice that's typically required. Or we could pick a new date for both of your parenting plans, or we could move them both to January 24th.
I believe I haven't seen the paperwork yet. As far as his proposed, I would be okay with keeping it on the 3rd though, I believe, since I think that I have all of my paperwork in that I need to have in for that.
Okay. And Mr. Denlocker, would you be in agreement to have your documents, because Ms. Lucor is agreeing, have both your temporary parenting plans looked at on January 3rd?
She has not had time to review any of the temporary parenting plan. I have not served her with it yet. Okay. And so there would be no proof of delivery within 21 days. That's why I put it out to the 24th.
Okay. Well, I was trying to help y'all here, but we'll keep it the way it is. Ms. Lucor, I don't know. I'm guessing when you come on the 3rd, the judicial officer may want to bump them both to the same date. So maybe the two of you can talk about whether you want to agree on a date that's maybe the week after the 3rd or something like that. I'll let you guys work that out, but right now it's Ms. Lucor's motion on the 3rd, yours on the 24th. But really, you're both asking for the same ruling, that is a ruling on the temporary order. So I think the judge is going to want to hear it all together rather than bifurcating. But anyway, that's for another day. Let's talk about the restraining orders. Since I received it first in time and there is a temporary order in place, Mr. Denlocker, I'll first hear from you about why you believe this is necessary at this time. Do you intend to give any additional testimony or rely on what you have submitted to the court already?
I do have some other character reference pages to attach, but I have sent you bench copies prior to our last meeting for court last Wednesday that has information, emailed statement from Heather Lucor's coworker and friend, Ellen Jordan.
Yes, I have received that.
And I have asked for a hair follicle test from Heather Lucor. I'm wondering if she has fulfilled any court order requirements. And then going into our daughter, Heather in 8 months has overslept, not getting our child to school. Our daughter has 24 excused absences, 12 unexcused absences, 54 tardies, and a total of 36 days absent in 8 months. I have also attached paperwork from the school stating that they were going to take her to juvenile court over said issues. What my question is if Heather doesn't have a drug problem, why is there the neglect going on?
Anything else you want the court to know?
Well, I guess not as of right now. I mean, the other things could be addressed with the temporary parenting plan.
Right.
I'm concerned about our child and what's going on. There's multiple people that have been asked by her landlord to not be over anymore. I'm worried about people that she's surrounding our daughter around. And then I've also attached in my bench copy for you last Wednesday, 11 UAs that I have taken as of recently. Actually, the last one was the day before, the Tuesday before last Wednesday. I attached that as well. And those are all at random. I have to make a phone call every single day to find out if I go in or not. So I just want to prove that I'm capable of taking care of our daughter. If I'm not trusted, then why would she leave our daughter with me when she went to Tennessee?
Okay. And Mr. Denlocker, I don't know, you probably haven't received it. I just got it this morning. It was filed this morning. It is from Ms. Lucor, and it's a 10 drug screen urine analysis result. And it is completely negative.
Okay.
And would not assume that you would have that information because it was handed to me just now. So I just wanted to let you know.
That's great.
Yeah, Ms. Lucor, go ahead and first, as it pertains to the request for a restraining order, we've done a temporary one, but this is your time for a hearing on the, I guess, more substantial restraining order, one that would last longer. I assume you're objecting to that.
Yes.
And why are you objecting to it?
Well, to start off, Emmeline has lived with me and had the same address as me her entire life. Brian and I have been broken up for around 6 years now. We have co-parented this entire time with no problems, no accusations of drug use or substance abuse, minus more so on his account from having multiple DUIs. And I have never been away from my daughter for more than 3 days in a row her entire life. So all of a sudden having a month-long stretch of not seeing or being able to talk to my daughter was incredibly difficult, I guess, to say the least. The attendance records, yes, I definitely admit last year I was struggling with a lot of mental health issues, as well as multiple people between my family and my boyfriend had passed away, as well as I had moved twice within 1 year. Actually, within 6 months, I had to move 2 different times because my grandma sold her house. And then we got a notice saying that our landlord was going to sell the house 3 months into us living into the new house. So we had to move again. That is not an excuse, but if you look at her records as of this year, she has had in 74 days, she has had 5.33 days excused absences. It shows, which 1.33 of that was since Ryan has had her. I was going to file this as well today. I just did not have my wallet with me as far as paying for the cover sheet. So I will file this as well, just so you have the updated copy of the attendance record. But as far as in the last 3 months, her attendance, she had missed 4 days total. She also received a SOAR award this year as far as her academics went. And my biggest problem is that if you look at the text messages between me and Ryan when I was in Tennessee with my grandma, because she was in hospice and she was expected to pass away, I 100% trust Ryan to watch our daughter. That's why my restraining order is not a no contact, because I believe this whole thing is detrimental to Emma. Ryan knows it is 100%. He has never once acted concerned about me taking care of our child. And so for him to, out of nowhere, because I refused to pay back child support, he threatened to take her. And I was in Tennessee, so of course there was nothing I could do as far as filing anything during that time until I got back. And I have multiple records of me calling over and over, me messaging him and pleading with him and his mother to please let me have contact with our daughter, because like I said, I've never went more than 2 or 3 days without talking to her or seeing her. And there's absolutely no valid reason to have a restraining order against me. And I will get him the copies of the urine analysis. I had called multiple places as far as a hair follicle. I did not find a place in town that did it specifically, but I just made the appointment about a week and a half ago, and that was the soonest they could get me in was yesterday. So I got the results in as soon as I possibly could, but I will serve Ryan with the copies of that as well as the updated attendance sheet. I don't know if he kept Emma there again today. I saw that he had kept her home last Wednesday. I'm trying to think if there's more that I should add, but I just really, really would love to have her home because this is her home, regardless of what Ryan is trying to act like or state and act like her home is with him, because they can't even legally really live where they're living at right now because it's a 55 and older community with his mom in a 2-bedroom place with 4 different people. So she has her own room here with her own bed and her own space. And we have lived here for over a year now.
So here's going to be my ruling on, first we'll do Mr. Denlocker's request for restraining order. And although,
Your Honor,
yes, sir, go ahead.
may I add?
Sure.
The statement about our daughter never being away from her longer than 3 days is false. I've taken my daughter on camping trips for weeks at a time.
All right, I'm not basing my ruling on that at all. No, sir, I'm making my ruling on the restraining order based on pertinent evidence as it pertains to the restraining order.
Yes, Your Honor, I would love to add something, please.
Go ahead.
The reason why I put a hair follicle test in place in my paperwork is because it tests back longer. The drugs that I'm concerned about her using leave your system faster than others. I'm talking like 3 days or something. So that is why I've requested a hair follicle test, and I've added that in all my paperwork.
Thank you, sir. All right. So when a person is requesting a restraining order, I must find that there's some real, more likely than not, meaning 51% chance or more, that there is a danger to the child should I not put the restraining order in place. If you're filing a full civil protection order, I have to find that there's been some act of threat of harm or some other type of unlawful harassment that has occurred. Although the standard in family law restraining orders is somewhat lower, and I am looking at what's in the best interest of the child, I find no credible evidence beyond allegations that a restraining order is necessary in this case to protect the child. I find that these parties absolutely should move forward with their request for a parenting plan, that within that request for parenting plans, if the parties want to ask the court to order hair follicle testing at the before visitation occurs, and if it is positive, then visitation is to cease. That is certainly something that the court can decide on at the time of entering these orders. But I will find in this case that this isn't a situation where one parent may have a substance abuse issue and the other parent never has and is doing great. I mean, the thing is, I understand why both of you may have concerns about the other parent, but none of it rises to the level for me based on what has been presented to me today and prior to today. None of it rises to the level that I would issue a restraining order completely denying parenting to someone who has parented a child for many, many years, despite absences at schools. That's concerning. It's not restraining order concerning. I understand, sir, your comment about hair follicle test going back further. The screen I have in front of me was collected December 19 at 4:55 p.m. What that tells me is that at least currently, the child would be perfectly safe with Ms. Lucor. So I am declining to grant any further continuances on the restraining order. It will be denied as of today. Ms. Lucor, I want to ask you, are you, given my ruling, are you still asking for your restraining order case to move forward?
Yes, I am mainly just worried as far as, because with it not being a no contact, I still want her to have contact with him. I worry mainly because of him continuing to discuss all of the issues he has with me, with our 8-year-old daughter. And I'm hoping that with what I put in the restraining order, as far as not harassing and not, all the different points in it, that would cover as far as him not being able to do that to our daughter, correct? That was basically my understanding of the restraining order.
You still have to prove that a restraining order is warranted. And I haven't heard that from any of your all's testimony today from you or from him. So I'm not inclined at this point, based on what's given to me to grant any party a restraining order. If you have additional evidence about why you believe he has harassed you or the child, I'm happy to hear it. And then I'll give him a chance to respond. But if it's just based on the evidence you all have already testified to, I am inclined to deny.
Okay. Yeah, the only evidence more that I have would really be if Emmeline were able to talk as well into it. But no, without her testimony, then no, I don't really have anything else to add.
Okay. Mr. Denlocker, anything else you want me to know about the request for a restraining order against you?
Yes, Your Honor.
Go ahead.
Heather's ex-boyfriend that she was referring to that died, he had a severe drug problem. They did not have a healthy relationship. Our daughter was around this a lot. This guy hung himself. It is not a healthy situation over there. My daughter wants, or our daughter, excuse me, wants to live with me. And she has told her mother that. As far as my living situation here, I actually just got the keys to a new place yesterday, and it is a 3-bedroom house with a garage, a big yard. Emma would have her own room. The reason why we are over at my mother's, which is a 3-bedroom house, was just temporary because of this whole situation.
Okay.
My mother is terminal, and I take care of her.
So again, there's nothing I've heard since we talked about Mr. Denlocker's restraining order that would change my mind. I do not believe a restraining order against either parent in this case. I don't believe the burden has been met to show that that's necessary to protect the child. So I am going to deny Ms. Lucor your request for the restraining / anti-harassment order. You all, that takes care of the 2 issues that were in front of me today. You all are scheduled back in front of the court January 3rd for now on Ms. Lucor's motion for temporary parenting orders. Is there anything else you need addressed today?
Your Honor, I would request Emmeline to stay with me until things are resolved in court.
I'm declining to enter that. I've removed the restraining order. So whatever visitation and custody issues were in place before the restraining order are automatically put into place as of 10:40 today. You can readdress that with your request for temporary orders.
So
There
since
there was
I have normally had her Monday through Friday, I am allowed to go pick her up from school. Like, we don't have anything in place. Technically, we don't have a parenting plan. We don't have a custody, nothing. In the past, I have had her Monday through Friday. He has had her Friday after school until Sunday. That has been our schedule. We don't have it in writing, but that has been the case since she's been in school. And so I know that you're saying that.
Well, here's the thing, y'all. My hands are tied because both of you have requested this court enter a temporary parenting plan in January. No one has timely put that in front of me for today.
Right.
Well, did put in front of me for today is restraining orders. I do believe you all are about to embark on a real bumpy road between now and January when you do have temporary orders in place. I can't fix that though, because that is not in front of me to decide today. And I am not going to without both of your materials have been served and exchanged. I can't address that issue for you. So unfortunately, you both are in a situation where there is nothing in front of me today that can fix or remedy what you all are about to go through between now and January 3rd or now and January 24th. I can't enter orders. Again, like Mr. Denlocker, you stated, you haven't even served her with your proposed, so I can't.
No, I have with the proposed.
I encourage you both to work together to get through the next month. I absolutely believe wholeheartedly that neither one of you should be talking to the child about this case or asking questions like, what do you want? Who do you want to live with? If you live with me, we'll do this. If you live with him or her, this will happen. I really strongly encourage you both. And I think that you both, given what I've seen in your filings, you both absolutely love and want the best for your daughter. So over the next 3 to 4 weeks before you have temporary orders in place, just remember that and try to work together as best you can. I can't issue orders today about custody.
May I ask if he kept Emmeline home today again? Because he kept her home.
Ma'am, you guys will have to talk about that after docket. Okay.
Your Honor.
Yes, sir.
Our daughter is very, very scared of her mother right now. She has told me that if she goes to school today and the restraining order is lifted, if her mom shows up to pick her up from school, she's going to ask the school to call 911.
Well, sir, I cannot control that. Nothing has been asked of me in a timely manner today for me to enter temporary orders. You all brought restraining orders. I ruled that I did not believe there was sufficient evidence to enter orders of restraint against either one of you. You all are back in January on temporary parenting plans. Again, I wish you the best of luck. I obviously can't control if an 8-year-old tells the school they don't want to go with their mom, but I can't insert myself into that without proper jurisdiction to do so.
Did we resolve the court date for January?
You have January 3rd and January 24th.
So both dates
Both
will
dates.
stay.
Yep.
Okay.
Okay. All right. I wish you all the best of luck.
Thank you.
Thank you.
Thank you.
And Denlocker, are you on the line today?
Yes, Your Honor.
Okay. Good morning, Mr. Denlocker.
Good morning.
Heather Lucor, are you on the line this morning?
Yes, I am.
Okay. Welcome to you. And Ms. Looney is present, and we are here. Let me get my notes for a moment. Okay, this is related to a motion for temporary orders. It looks like the restraining order has already been addressed, if I'm not mistaken. And there's at issue our parenting plan. And this was a little confusing procedurally, and I think I've got it clear in my mind. But there's one proposed parenting plan that's scheduled for today. There's another date noted for the 24th, which relates to another proposed parenting plan. My sense is that we're going to be addressing them both today. Is that your understanding? I'll touch base with Mr. Denlocker and then Ms. Lucor.
Your Honor, I'm asking for a continuance. I've been sick since before Christmas. It started with a sinus infection and then I got COVID. I'm still very sick right now. Heather has been not being able to be reached for all the papers that I've served her with. I've emailed them to her. Friends of mine have gone to her house. I've had paperwork in since the very beginning to Heather Lucor, and she has not received any of it. I'm just, it's all been documented with the court, filed, and she has not read or gone over any of it. I've asked with my restraining order for a hair follicle test. She provided the court after being told by the judge our very first court date that she would give her another week, and she provided a UA instead, which you only have to be clean for 3 days.
So let me touch base with you, Mr. Denlocker. You're making a request to continue this hearing due to illness. Tell me how and then you kind of mixed it with service issues on Ms. Lucor. So is it that you're too ill to proceed today, or is it that the illness interfered with your ability to prepare for today's hearing?
I'm not well, and nor has she received any of my paperwork that I served her with, attempted to serve her with days after she was served with the first paperwork, with the ex parte restraining order and proposed parenting plan.
Okay, so let me touch base with Ms. Lucor. Ms. Lucor, are you raising any concerns related to you being served documents, or are you indicating that you have been served documents from Mr. Denlocker?
I have not been served documents other
I missed
than
that first part. Could you repeat that?
yes. I have not received any documents from him. I also have been home quite often, as well as I have a roommate that has been here the last 5 days, pretty much all the time. I actually have messaged Ryan ever since the restraining order has been dropped. I have messaged him multiple times. I actually just messaged him again, I think it was 2 days ago, telling him I have not received any paperwork at all since the first paperwork he filed. I do have that in text message proof. I told him I also have not received any emails. I have not had anybody try to serve me papers. I asked him if we could somehow set up a time to make sure that I am home, or make sure that he has the right email address, because my email address is printed on the paperwork. So I don't know how he could possibly be getting it wrong, but I have not received anything from him. Ever since the restraining order was dropped, he refuses still to let me have any contact with our daughter, sorry.
Well, I don't want to go too far afield in this. We're talking about the request for continuance, and I asked about the service of documents, so I appreciate your input.
Okay. Sorry.
No, that's okay. Ms. Looney, do you have any input regarding the continuance and service of documents and the like?
There's no objection on the state's part for a continuance, Your Honor.
Mr. Denlocker, what time frame are you looking at as far as continuing?
I already put in a request for the 24th. If we could just continue with that, that would be wonderful. If Heather can tell me a time that she can actually be served with the papers that you guys have already stamped and is been filed. It's been in for quite some time.
Okay. All right, I'll grant the motion to continue the matter. Obviously, the service of documents is important. The parties can work that out amongst themselves. And we will be here on the 24th at 9 a.m. to address the issues that have been raised by the parties.
Thank you, Your Honor. I really appreciate it.
May I ask a question?
You may.
Is there any way I can have contact with her?
So in granting the continuance, I'm not hearing the merits on the issues related to parenting time or residential time. The parties can come to an agreement, then that can happen, obviously. And obviously, I don't think there's any restraining orders that prevent Ms. Lucor from having contact with the child. Obviously, if a child is being withheld, that's obviously frowned upon. But if there's other reasons for that, that's something we can address on the 24th of January. So granted the continuance, I'm not getting into the merits as far as visitation. So we'll see everybody on the 24th. That'll conclude that matter. Thank you.
Thank you.
Thank you. You have a great day.
And then Ms. Looney, you indicated your last matter is the Denlocker and Lucor matter.
Yes, Your Honor.
Okay, let me just pull that up just one moment. Okay, just double check. Ryan Denlocker, are you on the line today?
Yes, Your Honor.
Okay, good morning to you. And Heather
Good morning.
Lucor, are you on the line? Heather Lucor, if you're here, make sure you're unmuted and state your name, please. All right, not seeing or hearing from Ms. Lucor. Mr. Denlocker, have you heard any communication from Ms. Lucor about her absence or potential absence today?
No, she told me last night, she sent me a long text message stating that, that it was messed up in the paperwork that I served, and wished me a good luck in sarcasm for today.
Okay, all right, thank you. Let me just, you had submitted, one moment. I have a couple of documents. I'm just going to double check that, make sure I have those documents before me. Okay, so yes, I have documents here. Just pausing 1 second, Ms. Looney, if you have already sent the documents on Baker and Hall, thank you. If you haven't, don't worry. I found them at the bottom of the file.
Thank you. I'll let my assistant know that we don't need to resend them.
Okay. All right. Just take a moment and sign off on those. All right. Thank you for your patience. I appreciate that. All right. So, Mr. Denlocker, I have proposed orders that have been submitted by yourself and also Ms. Lucor. And I just have those here. So I have from you a proposed order of a parenting plan and a temporary family law order. And it looks like I have 2 parenting plans from you, which is okay. I'm assuming they're the same.
They might be. I sent in a proposed and a parenting plan, temporary order as well.
Okay. Yeah, I'm just looking at them. Looks like they are identical. I mean, the spacing, the handwriting, everything is identical. So yeah. Okay. So as far as the motion initially was, I'll first hear from Ms. Looney, get your input, and then I'll hear from Mr. Denlocker, please.
Your Honor, we would just be asking if the custody is changed to Mr. Denlocker, that we would have a bench order that would end his child support obligation today, and we would cite a new hearing on to address child support in the future.
Okay. All right. Thanks. All right. And Mr. Denlocker, regarding your motion or your request related to the parenting plan, I'll hear from you.
Thank you. So I've been suspecting for quite some time and really couldn't do anything about drug issues with my daughter's mom. I wasn't in a position to have our child under my roof. I didn't have a room for her. I know she needs her own room. I have since completed that, and she does have her own room. She lives in a loving home. She's been under her mom's roof during the week for school. Her mom lives like 2 miles away from the school. It's a 2-minute drive or a 15-minute walk. I have put those papers in attached as well.
And that's entry.
Correct.
Okay.
When I first submitted the paperwork, I had requested the school attendance records, and it shows that Heather overslept 32 times in 8 months. Emma has 24 days excused from school in 8 months, 12 unexcused absences, and 54 tardies, with a total of 36 days absent. That
little days of absence.
Yes, 36 of them absent and 8 months.
Okay.
That I don't know what's going on there besides what I was stating, that I believe that her mom is using drugs, and hard drugs on top of that leave your system within 3 days. I was requesting a hair follicle test. She has pretty much refused. She did supply a urine test, which I don't think is sufficient. Currently, our daughter she has not wanted to live with her mom for quite some time. She had talked to her mom about it and was pretty much begged to give her a second chance. Heather has tried to pick up Emma twice from school since we've been going to court over this issue. One time I kept her out of school thinking that Heather would do that because I had court that day, and she most certainly did go to the school. Emma was not there. I called her out of school because Emma was scared to be at school and possibly be taken out of school because of her mom. Our last court date on the 3rd, which I had you as a judge, I was just getting over COVID and I asked for a continuance. Heather directly went to her school to withdraw her. Emma stood up, had a private conversation with her teacher, told her that she did not feel safe going with her mom, and that is not me to pick her up early from school. The office relayed the information to Heather Lucor. Later on, the principal, Miss Micheletto, pulled our daughter aside and had another conversation, making sure that she is okay. And Emma told Miss Micheletto the same thing, that she did not feel safe going with her mom, and addressed some of the issues that is going on. I have spoke with Miss Micheletto. She's the vice principal at Lexington Elementary. I asked if she would possibly be willing to provide any information for the court for me, and she said that they don't typically do that, but she would be more than willing to give you any information needed if you guys wanted information from them. I've attached 2 letters from Lexington Elementary that Heather and I received at the end of towards the end of the school year last year, stating that they were going to take Heather to court if there was any more further unexcused absences. If she's not using, I don't understand what the problem is. I pick up Emma from the school bus in front of Heather's Lucor's house on Friday. And Emma stays with me till Sunday night. I always offer to take Emma home at a reasonable time because it's a school night on Sunday. and Heather chooses to offer to pick her up from me at a set time that we talk about, but every Sunday she continues to be later and later and later and later. Sometimes she doesn't pick her up till 10:30 at night on a school night. And often they don't even go home right away. She still has to go grocery shopping or something, which I don't understand given that she's had all weekend to herself. Um,
Can I ask a
Emma,
clarifying question?
sure.
In your temporary family law order, you're asking for a restraining order. And I know that you have some restraints within the proposed parenting plan, but did you have a separate restraining order? I didn't see one proposed from you.
No, I didn't put in a second one because I initially asked for a ex parte restraining order while Heather was still in Tennessee because she had been threatening to take Emma out of the state against my will.
Okay.
I was leaving the restraining order part up to you. Heather's been threatening me. Her family's been threatening me, making phone calls and text messages to my mother, who is terminal, showing up at her house. So our last court date that I had with you on the 3rd, when I asked for a continuance, Heather had gone straight to the school and tried to withdraw Emma, like I had stated. And Emma did not want to go with her. She immediately called the Longview Police Department asking for a wellness check. Officer McDonald called me. I have submitted all the CAD paperwork for that as well. Officer McDonald had called me. I talked to him. He had already spoke with Lexington Elementary School. And I just told him my side of things. And he said he didn't feel a need to come out and do a wellness check. I told him he was more than welcome, or anybody in the police department is more than welcome to come and check on Emmeline at any time. I'm not aggressive or upset about anything. I just want what's best for our daughter. And I want Heather to get the help that she needs to be a parent. I'm not trying to keep Emma away from her mother. Her mother needs help. And I'm very worried for her. She's surrounding herself with people that don't breathe life into her. And Emma is around constant yelling and screaming. Heather's got a boyfriend that isn't even allowed to see his own child. He is not allowed at their house. Heather rents from her friend.
Mr. Dunlop, do you mind if I just interrupt?
Sure.
I appreciate you sharing that information, and it's information that was mostly shared within your pleading. So I've seen that, and I just see that Ms. Lucor has just joined our call right now. So I'm letting her in.
Okay.
Okay, Heather Lucor, can you hear me?
Yes.
All right, Ms. Lucor, I called your case probably 10 minutes ago, and maybe a little bit less than that. And Mr. Denlocker is on the line. And I had asked him if he had had any communication with you about your absence here this morning. He indicated that he had some type of communication with you last night. And then I didn't see you here today, so I proceeded to hear from Mr. Denlocker and also Ms. Looney, who's a representative of the state related to child support and the like. Ms. Looney had indicated that she, if there were a change in the parenting plan, then she would be asking for some child support. And then I've been listening to Mr. Denlocker explain his position. So I'm just curious. So at this point, I guess we kind of start fresh with the hearing. So I have proposed orders from both Mr. Denlocker and Ms. Lucor related to parenting plan, restraining orders, and temporary family law orders. So I'm going to hear from Mr. Denlocker if you want to start again, and then we'll hear from Ms. Lucor.
I'm just asking the court to protect Emmeline. She does not want to be in an abusive home. Heather is constantly yelling and screaming with her boyfriend, Adam Davis. He is no longer allowed at their house, even though he still continues to be at their house when Heather's housemate isn't home, which I have provided bench copies of license plates and photos of that. Heather rents from her friend who purchased the house that they lived in. He has asked her not to have him over. He is not allowed at that house because the neighbors have complained so many times from yelling and screaming that Heather's housemate had to ask him to no longer come over. I don't believe that this is a good situation for Emmeline, as well as the other people that Heather chooses to surround herself with. I did some background checks on some people that Heather hangs out with. They have questionable backgrounds, including burglary, assault, drugs, evading police, felonies, just to name a few. I want my daughter to be around who I don't want my daughter to be around, and that she has stated that Adam Davis is not allowed to see his own daughter. I asked the court that this man have no contact with Emmeline. Heather's got a repeated history of hanging out with people that are not healthy for our child. Heather's last boyfriend committed suicide. I don't know that she's ever gone to counseling or anything for this. They were both using drugs together. I've put in statements from Heather's coworkers and friends that Heather admitted to them that she was using drugs. I've asked for a hair follicle test. As of right now, I want what's best for Heather. I want Emma to have her mom in her life. I want her mom to do better for herself. But I'm asking for supervised visits once said things can be achieved. My daughter is she's very special, and she's very scared. And she does not want to see her mom. She told her teacher that she does not want to go with her mom. She has told her mom that she wants to live with me. And that is what I'm asking for right now, is to get Heather back on track. And, I care about her mom. And I want Heather to do better for herself and be a better parent. The school attendance, the letters from the school, the constant going over to the school trying to withdraw Emma from school after said court dates. It's just the harassment from her family and blasting me on Facebook all the time with attached. I've attached everything with people stating he needs an ass whooping and blah blah blah, slandering my name. It's just completely unnecessary. I have not sent her one single message this whole time since I put in the ex parte restraining order, and she continues to send me message after message and phone calls. I understand that she wanted to see her daughter during Christmas and her birthday. I get it. I totally do. But Emma is scared, and I just want what's best for Heather.
All right, Mr. Dunn.
Me at some point in time. He has never brought up any of these points to me that he's concerned or sat down and had a conversation with me. We have been co-parenting together for 7 years now. we've been broken up since Emma was 2 or 3. And we had, I thought, a fairly good co-parenting relationship, which is why we never had a parenting plan put in place. I also had never asked him for child support before this last year, which I didn't ask him for. I applied for TANF. The state went after him for child support. He has been upset about it ever since. He has told me that he wanted me to return payments to him, that he feels he shouldn't have to pay child support. Even though I have Emma 5 days a week, he still feels as though I should. He feels almost as if he has her 50-50, even though he, on a normal basis, has always had her Friday until Sunday. And then I picked her up Sunday and I had her until Friday when she went to school. And that has been our schedule for years now. And I have attached proof from text messages between me and Ryan Denlocker from when I was in Tennessee. And those messages show that I was asking him if he was okay with Emmeline flying out to Tennessee to meet me while my grandma was in hospice, because it was very important to my grandma to see Emma. We had lived with her all the way up until a year and a half ago, and they were very close. Emmeline also expressed to me that it was very important to her to see my grandma, and she was very, like, overly excited about it once me and her were talking about the possibility, because she was out of school the following week after I had went out to Tennessee. I was only planning to be in Tennessee for the 5 days that I ended up being there. But while I was there was when it was discussed about Emmeline flying out there as an unaccompanied minor. My grandma was willing to pay for the ticket and pay for any expenses that needed. I was discussing the possibility with Ryan. It was never, ever a question that we would return. It was never me leaving Emmeline with him, as in, like, she's moving in with him. It was never a case like that.
Ms. Luke, do you mind if I just interrupt? It looks like Mr.
Yeah.
Denlocker fell off of the call.
Oh, okay.
So let me just double check. Mr. Denlocker, are you on the line? Okay. Usually what happens, people drop off and then they usually come right back on. So
Okay.
let's just pause just a moment.
Okay.
Double check. Ryan Denlocker, are you on the line? Ryan Denlocker. Okay, there's no response there. I'm just going to give it another 30 seconds. And then we'll just kind of play it from here. From that point, probably what we'll do is we'll probably suspend the argument for a bit, give him additional time to come back onto the line. I know that the state's involved and they have to get going, but we're just going to wait another 20 seconds or so, give him an opportunity. If not, then we're going to pause on this case and move to a different one. And my apologies for that.
Okay.
And
Well,
Your Honor,
would we come
do
back
have
to?
additional time, so I don't need to leave until 10:30. So it does look like he's coming back.
All right, thank you.
I'm sorry, I
All right,
must
Mr.
have pushed the
Denlocker, are you
button
back
and
on?
it kicked me out.
Okay, all right. Mr. Denlocker's back. Go ahead, Ms. Lucor, with your presentation.
Okay. But as far as us being, or me requesting that Emmeline come out to Tennessee, he has from the beginning stated it as if I just left her with him while I moved to Tennessee, and then I'm trying to come back to take her and bring her out there with me. And that was never the case. I was only supposed to be in Tennessee for 5 days, and that was as long as I ended up being there. I went there to see my grandma, who was moved to hospice and not expected to live much longer. Like I said, the discussion of Emmeline flying out there for a week was discussed. He did agree that he would let her do that, but only if I put in writing that I would pay him back child support and that I would allow him to have her every holiday and every birthday, and that I agreed that I would come back on the 25th, which was the discussed date that me and her would fly back. It was never a question of if we were coming back or if we were moving there. Of course, I was never going to just take her to Tennessee or have her fly out there and never return. All of my belongings are here. My home is here. My dog is here. My car was here. I was never ever stating that I was trying to move there or stay there. It was never a question.
Can I ask you just a directed question, if I may? Mr.
Yes.
Mr. Denlocker had raised concerns regarding drug usage. Do you want to address that?
Yes. He has never brought those concerns up to me. I do know that he has asked my roommate about it, which my roommate has told him that he did not believe that I was using any drugs. And I have also, it's never been brought up directly to me. But as far as this court case goes, I did provide a urine analysis. I was not court ordered to do that. He did request a hair follicle test. I did not honestly feel as though I needed to provide anything that wasn't court ordered. I did still go ahead and do the urine analysis to show that I am clean and that I am not using drugs. I don't even drink. As far as the therapy goes, I have sought therapy ever. Like his main points, as far as my ex who committed suicide, he claims that I never sought therapy after that point, and I did go to therapy. I have been to therapy multiple times since that point, which was over a year ago. And I am not using drugs. I was not using drugs. I don't know. I feel like this has just been an ongoing accusation of Ryan's. He has no proof of anything he is alleging. He just, and the way that he's stating everything, he is acting as if Emmeline has been living with him for X amount of time. She's never lived with him, ever. Like, she has lived with me Monday or Sunday through Friday for her. Like, I've never been away from my daughter more than 3 days.
Okay, well, I appreciate the input, and I did read everything that was submitted by the parties, and so we have a big docket today, so I'm going to necessarily have to stop the sharing of the verbal feedback, but I did read everything that was in the file. So just one moment. So with regard to the situation as it stands now, there's a lot of conflicting information. One thing that I'm going to ask both parties to do, I want you both to take a hair follicle test no later than Friday of this week at 5 p.m. So you both will need to pay for and submit to a hair follicle test. And we'll be back here on the 21st of February at 9 o'clock in the morning to review those results. So once you get the results back, you'll need to file those under seal with the court and provide copies to the other party. I'm also appointing our family investigator, Ms. Schaefer. She's going to do an investigation where she'll do a quick investigation to check for safety in the particular homes, because, like I said, there's allegations flying both ways of domestic violence and drug usage and the like. And so we'll return on the 21st of February for her report, and she will be in touch with you. In the meantime, I'm prohibiting either party from introducing or continuing to expose the child to any romantic interests. That both parties are prohibited from removing the child from the state, and both parties are prohibited from changing any school enrollment or school status of the child. For now, it's going to be a 50-50 plan. So starting Friday, January 26th, after school, if school is in. If school's not in, then 5 p.m. then that will start Mr. Denlocker's week on from Friday at after school or 5 p.m., depending on school status, until the next Friday at 5 p.m. or after school. And then at which time it would be Ms. Lucor's time with the child. So that would be, her time would start on the February 2nd. Then it'll continue to alternate in that fashion. We'll be back here on the 21st of February to hear from Ms. Schaefer related to her investigation. And then we'll take additional steps forward to address the concerns that the parties have raised. So any questions from the parties?
Yes. Could you state the dates again? And, Emmeline doesn't want to go with her mom.
So I've made my ruling so that you ask for a request for your date of Friday. Your parenting time starts on Friday, the 26th, and then Ms. Lucor's parenting time will start on Friday, the 2nd, either after school if school is in session on that day, or 5 p.m. if it is not. And then you'll continue to alternate weeks in that fashion. So I will draft a bench order to that effect. I'll file it, and the parties can look for it in Odyssey. And we'll be back here on the 21st to review those results from the family investigator.
So what happens until Friday? Is she supposed to be with me, or how, or does?
Wherever she's currently residing, that's where she'll stay until that Friday.
So I'm sorry,
home,
Friday, January 26th, because she has been with him
whomever's
because
home she left to go to school today. That's where the child will stay until Friday. And if the child's been with dad, then she'll stay with dad until Friday. If she's been with you, then she'll stay with you until Friday.
Okay. So then he would have her until next Friday, because his would start this Friday until the following Friday, and then next.
Correct. And then on February 2nd, Friday, would start your time after school if school is in session, or at 5 p.m. if school is not in session. Looks like Ms. Lucor is frozen. So I'll draft an order and submit that to the parties. We'll submit it to the court for filing. Mr. Denlocker, any final questions?
I do. I'm on probation, and I do take random drug tests. I have to call a hotline every single day. It screens for everything.
So you're asking about the hair follicle test?
Yeah,
So you're ordered to do that, to take
okay.
it?
Yeah. Okay.
All right. So that'll conclude the hearing. We'll see everybody. All right. Let me double check with. I see Miss Looney's assistant is on the line. Is Miss Looney on the line? I know that she looks like she's involved in 2 cases, but I don't think that directly involves child support.
That's correct. She's out of the office, but I'm just observing in case something comes up that will affect child support.
Perfect. That's kind of you. Thank you. I appreciate that input.
Your Honor.
Yes.
I am also asking for a continuance. My name is Ryan Denlocker.
Okay.
Right. I'm asking for a continuance due to the fact that Heather Lucor has not provided a court-ordered hair follicle test yet to show the severity of her drug use.
Okay, this is cause number 23349408. This is Ryan Denlocker and Heather Lucor. I see Ms. Lucor, your camera's on. Can you hear me okay?
Yes, I can.
Okay. And the family court investigator, Schaefer, are you on the line?
Yes, I am.
Okay, great. All right, so there was a request to continue the matter based on an indication from Mr. Denlocker that there has not been a hair follicle test submitted by Ms. Lucor. Is that your motion, Mr. Denlocker?
Yes, Your Honor.
Okay. And Ms. Lucor, any updates as far as that hair follicle test?
I had gotten it done last Wednesday. I went in yesterday and the day before trying to see if they have gotten the results in yet. They said it was still pending. I have in the meantime, which I did update Jennifer, that I did go into detox at Columbia Wellness. I did file those papers. That has my discharge paperwork, my treatment plan, my crisis plan, as well as my papers from Kelso Comprehensive Treatment Center, which is where I do the methadone at. I get dosed daily, Monday through Saturday. There with methadone, we get take homes on Sunday. So I do understand that I haven't submitted that yet. I would if I had it. I got it done I got it done a week ago, and they said that I should have the results by Friday at the latest Monday. So I don't know why they haven't got it done yet. The only reason I didn't get it done right away was because I didn't know if I needed the 5-panel or I think it was a 12 or 17 panel. And it was a $200 difference between the two. And right when we were ordered to get it done, I did not have $350 to do the larger one. So Miss Schaefer said that she was going to try to contact you to find out which one we were supposed to get, which she had stated to me that she did not hear back. So I went ahead and did the 5-panel. And like I said, I am just waiting for those results to get in. I did know that it was going to show meth and fentanyl, honestly. So I did go through with doing detox at Columbia Wellness. I was there from midnight on the 15th until about 1 o'clock in the afternoon on the 18th. I am willing to do random UAs. I am willing to do anything that you guys ask me to do. I am set up to do outpatient at Columbia Wellness. My intake for that is on this coming Friday on the 23rd. And then following that, I will be doing 3 days a week, 3 hours a day. And then I already had my psych eval with Columbia Wellness. So originally I was going to go to Awakenings for the mental health part, but I decided to do my outpatient and mental health through Columbia Wellness. And then with the Kelso Comprehensive Treatment Center, I also see my counselor one-on-one once a week. I go to group once a week, and then I'm supposed to do one NA meeting once a week as well. So, and then I'm also getting signed up to go back to college as well. So that is my plan as of right now. The only reason I disagree on the continuance is the fact that I do know that it is going to show drugs in my system. And I went through with doing the detox and taking the steps I needed to get sober and make sure that I can, from here on out, I will be clean and there's no question about it. So I think that is it.
Okay. Thank you. And again, I just want to touch base with Mr. Denlocker before I hear from Ms. Schaefer. Mr. Denlocker, your request to continue is based on what?
To show the court the severity of drug use. I've requested a hair follicle test every court date we've had. Our last court date, you gave Heather time to take a hair follicle test, and you also asked me to take a hair follicle test. I've submitted that. You decided to do 50-50 visitation for 1 week on, 1 week off. Heather's first week of having our daughter since November 10th, of the first full week that she's had her, according to the last judgment, she did not even pick her up from school on Thursday the 8th, the 1 week that she's had her. I got a phone call from the school, and so did my sister, asking to pick up our daughter, or my daughter. it was 4:04. Emmeline gets out of school at 3:25, and I had to call Heather. Sounded like I woke her up. And this is a problem.
May I comment on that?
Yeah, one moment, please, Ms. Lucar. I want to hear from
Okay.
Ms. Schaefer. Ms. Schaefer, there's a request to continue the matter. I'm leaning towards not, and I just wanted to get your feelings.
I think like I submitted a restraining order to kind of keep the child in Mr. Denlocker's care until Ms. LaCour could get set up in counseling and start to show have a little bit of time to show that she's able to follow through with it. I don't see that a continuance would change anything for that. She has admitted that she is using, that she needs to get help. She's taking the steps to get help. So I'm not sure that continuing would change anything at this point.
Okay. All right. Thank you.
Your Honor.
I'll deny the request to continue the matter. We'll hear the matter today and make some decisions today. So I've read over the family court investigators' reports. I'm assuming that both parties, Mr. Denlocker, did you receive a copy of that?
Yes, Your Honor.
Okay. And then Ms. Lucar, did you receive a copy of the report?
Yes, Your Honor.
Okay. Ms. Schaefer, anything you'd like to add in relation to your report? I've reviewed it and I've looked at your recommendations, so I'm familiar with it.
The only thing that has changed is that Ms. LaCour did email me last night with all of the documentation from her treatment and patient, and that was not included in my report, but she has presented that with me, not with the court yet, I don't think.
And that's the same.
I did file it.
Okay.
That's the same information that she reviewed today related to the detox and being discharged there and then having an intake appointment and then intensive outpatient planned.
Correct, yes.
Okay. All right. Thank you. All right. Well, I'll hear just from Mr. Denlocker and then from Ms. Lucar related to the recommendations.
Your Honor, the week that Heather had her between the 2nd and the 8th, she admitted to Jennifer Schaefer that she was in fact using drugs with Emmeline in the house. I'm asking the court, Ms. Schaefer's report was somewhat faulty from the information that I had told her and in all the paperwork that I've submitted to the court. I am asking the court for sole custody of my daughter until, basically just so Heather can prove to me and the court her sobriety. I petitioned the court in November with my concerns of Heather's neglect, drug use, emotional abuse, and failure to protect a minor. After being served Ms. Schaefer's report, I am extremely concerned with Heather's admission to Ms. Schaefer that she was using fentanyl while my daughter was in the house and failed to pick up our daughter from school on Thursday, the 1 week that she had her. Heather states that using fentanyl does not affect her being a parent, and that's pretty concerning to me. Heather lied and manipulated the court, placing my daughter into her care, and the court placed our daughter into her care, knowing that she was using drugs and continued to use drugs anyway, placing my daughter in harm's way. Heather admitted to using drugs while my daughter was in her care and admitted to driving with my daughter while she was in her care on drugs. I asked that Emma not to be allowed in her care, basically for the time being.
Do you have any thoughts as supervised limited visitation?
Supervised possibly, but I think that the schedule of treatment and counseling needs to go a little further, in my opinion. I want Heather to have the success that she needs, and this is affecting our child greatly. I asked Heather to provide a biweekly instead of a once a month, and before any visitation, I do want our daughter to be able to see her mom.
but I want Heather to be successful in her treatment. This is not a new addiction. This has been going on prior to 2021 and has continued to get worse. I mean, she's admitted to using meth, heroin, and fentanyl. And I'm, you know, Jennifer submitted new copies of a recent attendance record from 8/31 to 6/14, while Emma was still in Heather's care and partly in, yeah, pretty much in Heather's care. And it shows tardinesses and absences on it. I provided prior 8 months of school, most of it being last year, and the results were ridiculous. I have it submitted. I don't have that paperwork in front of me, but it's something like 54 tardies, and I mean, just a ton of absences. I think 12 unexcused. Lots of overslept times. Since Emma has been in my care, besides the couple of days I have withdrawn Emma from school for court reasons, because Heather showed up at the school immediately after court when the ex parte restraining order was lifted and tried to withdraw our daughter early from school. Our daughter was petrified to go with her. She wants to live with me and is scared to tell her mom that, because she's in fear that her mom won't love her anymore. But I truly believe that, you know, it's in Heather's best interest to get a little further with her program and sobriety before any kind of unsupervised visits.
Okay. Thank you, Mr. Denlocker.
Thank you.
Ms. Lucor and then Ms. Schaefer.
As far as the Thursday that she was in my care, I had a really, really horrible migraine. I normally would have picked Emma up. I contacted the school and asked them to put her on the bus home. They transferred me to the bus garage to talk to them about, because she hasn't taken the bus very much this year, since she had went back into care with her dad, and then it was her first week back with me. So for the most part, I was taking her, so I didn't remember which bus she was on. So they transferred me to the bus garage. I found out what bus number. I called back the school. I gave them the bus number. They did not give her the note to get on the bus to take the bus home, is what happened. And as soon as Ryan I don't know why they didn't contact me. They said they didn't have an updated phone number for me. I since then have updated my phone number with them. I don't know why they didn't have an updated phone number for me, because I gave it to them. But so as soon as Ryan contacted me saying that Emmeline was still at the school and hadn't taken the bus, I got up, I went there, I picked her up right away. It was not a lack of being a parent. It was not me forgetting about her. It was not anything like that. I went through the steps of making sure that she got on the bus to come home. So that part, I definitely disagree. It was not me just not showing up.
Can I ask a question? So
Yes.
back in January 25th, the court ordered a 50-50 split time, and it's indicated that you're using illegal, I'll call them death-defying, death-causing drug, fentanyl, while you had your child with you. Is that accurate?
The only time that I would use is in the evening when she would go to bed. I would smoke a little bit, solely because I was going through withdrawals so severely. I had tried to detox on my own multiple times, which
Okay,
but
that's enough. Yeah, so that's it. Detoxing, I've heard, is absolutely an incredibly difficult, physically exhausting, horrible experience. And when a parent is continuing to use those types of drugs, which you don't know the mix of, you may go to sleep that night and not wake up and your child finds you. I can't endorse that at all. And I'm not going to endorse that. So I'm going to quickly reverse what was done previously. And it looks like Judge Basher had gave custody to the father currently. So I'm going to follow the recommendations, but I'm going to tweak it a little bit. The primary custody of the child will be Mr. Denlocker. Ms. Lucor has taken the hair follicle test. She'll need to submit those results to the guardian ad litem and also to Mr. Denlocker and file them with the court. It looks like the evaluation has been completed. We'll anticipate that Ms. Lucor will follow through and have great fidelity in her treatment. As far as this visitation for the mother, all visitation by the mother of the child will be supervised. Either it'll be a person as recommended by Ms. Schaefer, by somebody that's approved by the father. If not, then she can pay for the supervisor, and that'll happen from on Saturdays, noon to 4 p.m. That'll be supervised at all times, not to leave the county. The supervisor has the right to terminate the supervision if Ms. Lucor appears to be under the influence, and that's impacting her parenting. There'll be, before moving up to any change, there'll be a 45 days of clean time as required and manifested by UAs. Ms. Lucor will need to have at a bare minimum 2 UAs per week, and she'll have to submit those results on a regular and continuing basis to Ms. Schaefer and to Mr. Denlocker and to the court. A bare minimum of 2 per week. So once she's had 45 days of clean time, then the time can be expanded on a Saturday from 9 a.m. to 8 p.m. Once she's had 100 days of clean time, then actually 120. Fentanyl is a tough one. 120 days of clean time as manifested by UAs, then there can be an overnight starting a Friday after school to Saturday at 8 p.m. And then once there's 6 months of verified clean time through the at least 2 times per week UAs, then it can have a overnight alternating weekend schedule of Friday after school until Monday at school. And that'll be on an alternating 1st, 3rd, and 5th type arrangement. In addition, Mr. Denlocker is prohibited from using alcohol while the child is residing with him during his time. When the child's not with him, that requirement does not apply. Both parties are restrained from introducing to the child any romantic interest for a period of 9 months from the beginning of the relationship. So that'll be the court order. Any questions or clarifications?
No, thank you, Your Honor.
Okay.
So will it get reevaluated, like once there is rotating weekends? Like, is there going to be a possibility for there to be 50-50 after that point, after the 6 months?
So recovery is obviously, it's a journey, and there's many steps each day in that journey. And the hope that Ms. Lucor, you'll be very successful in your treatment and in your recovery efforts. What the court is looking for is stability of parents. When parents are stable, children tend to be much more stable. So when a parent has exhibited stability and good parenting for an extended period of time, there's always that option for any type of motion to potentially modify a parenting plan. But the key part of this all is continued sobriety and the recovery. That is the absolute key.
Yes, sir.
Your Honor, I do have one more thing.
Go ahead.
I'm asking if I could claim MLN on my tax return for the first time.
You'll need to file a motion. We don't do those on the fly. You'll just need to file a motion, then note it up for a docket.
Okay, thank you.
All right. So, Ms. Schaefer, any additional items you need to address at this point?
No, Your Honor, thank you.
Okay. So just so the parties are aware, I will draft that revised parenting plan and submit it. And the parties can check with the court clerk's office probably 2-3 days and get a copy of it.
Thank you, Your Honor.
Okay. All right. That'll conclude the matter for today. Thank you.
Thank you.
Okay. if we could call please the Ryan Denlocker and Heather Lucor matter. This is cause 233494-08. Ryan Denlocker, are you on the line today?
Yes, Your Honor.
Welcome, sir. And Heather Lucor, are you on the line today? All right, Ms. Lucor, if you're on the line, I'm not hearing you. Please make sure you're unmuted and state your name. All right, not hearing a response from Ms. Lucor. Ms. Looney is here representing the state. And looks like as far as this is the state's motion for a temporary child support order, it looks like there was a docket notice sent to Mr. Denlocker at 2 different addresses on Willow Point and on also 48th Avenue. Mr. Denlocker, did you receive copies of the state's proposed orders and their motion?
Yes, Your Honor, I responded.
Great. And you indicated some concern that Ms. Lucor, for lack of a better term, was trying to buy you off. I read that in your response.
Yes.
Okay. And again, let me just make sure, Heather Lucor, are you on the line today, Heather Lucor? Okay, not hearing a response. I'm just going to type her name in the participant panel. And I don't see her there, so that confirms that she's not present. Okay, so I'll hear from Ms. Looney. Ms. Looney?
Thank you, Your Honor. We are proposing that we put in place a temporary order as the child is now living with Mr. Denlocker. That way, we would have an order in place that would require Ms. Lucor to pay $388 per month in child support. We have imputed her income at the minimum wage, 32 hours per week, as a recent TANF recipient. Since we have presented our proposed orders, we did receive information that Mr. Denlocker is now on TANF with the child. So we are asking that the section be filled in, that there is no deviation. We did leave that full deviation section in case the parties had come to an agreement. But now that there is TANF again for the child, we cannot recommend a lower payment for Ms. Denlocker, or I'm sorry, Ms. Lucor. That would be section 9 on page 3 of the order. We'd just be requesting that it be marked no and that there was no deviation requested.
Okay, so no deviation. Neither parent asked for a deviation from the standard calculation. That's the right one, correct?
Yes, and on section 10, we would just ask that the amount be filled in for $388 as the amount of support.
Okay.
And one additional change we are asking for is in section 11, just below that table. We did originally have April 1st, but the child began TANF on March 1st, so we're requesting that support begin March 1st.
Okay. All right, thank you. Mr. Denlocker, any questions about the proposed child support order requiring Ms. Lucor to pay $388 per month in support starting?
I don't really understand the whole circumstance. I went to DSHS office and they recommended me to apply for TANF to get the ball rolling. I told them that I did not really care to sign up for TANF, but I did actually need some more support financially. Heather bribed me $5,000, and that if that wasn't sufficient to go against your court ruling, that to pick a number. I have back owed child support. I've had my daughter since November 10th. And I don't know how long Heather was on TANF, but she basically applied for TANF because she did not want to work. She's always worked. And she recently received some inheritance from her grandmother passing, and tried to bribe me to go against your court orders. I feel like if she's able to bribe me, that, you know, at this point, I feel like I've been supporting her drug addiction and not our child for the past time that she's been on TANF. I'm kind of at a loss at what she's been doing and forced me to take these court actions.
Okay. All right, thank you. Let me ask you, Mr. Denlocker, the state served you with a copy of a proposed child support order and also corresponding worksheets.
Yes.
Do you have any objection to those?
Well, the first one, it says the basic child support obligation is $1,073. The most recent one shows a basic child support obligation of $939. I don't really know how to address these things. I'm not a lawyer, but I do have that pulled up. Heather, since our last court date at the end of last month,
So, Mr. Denlocker, maybe just more to the point, just a question. So the
Sure.
state has made a motion for child support that Ms. Lucor pay that amount starting March 1st. Are you in disagreement with that or in agreement with that?
I'm in agreement with that. I feel like the number is a little low. I don't prefer to be on TANF at all.
Sure.
That's not something I really wanted to do. I was pretty much talked into it at the DSHS office. I was so by the
So I guess that there's no objection, at least from my standpoint. There's
no
for me to grant the motion that the state has requested with the modifications that Ms. Looney had mentioned as far as March and also the marking of those 2 boxes as far as the deviation. So I've signed both of those. So at this point, I think that the motion is complete and I'm granting that request. So
okay.
appreciate
Thank you, Your Honor.
Lucker, Ms. Looney, thank you very much. That'll conclude the case for today. And Heather Lucor, which is cause 23-3494-08. I'll ask if Ryan Denlocker is on the line or present. Ryan Denlocker, if you're here, make sure you unmute and state your name, Ryan Denlocker. I'm just going to take a look at the participants on the Zoom call, see if there's anybody with a similar name. There's nobody with a Ryan and there's nobody with a DEN. So it looks like he's not present. And then I'll ask if Heather Lucor, if you're present. Heather Lucor, are you present?
Yes, I am.
Okay, Ms. Lucor is present. All right, so this is your motion, Ms. Lucor, to modify the parenting plan and appoint a guardian ad litem. As far as service of your motions and documents upon Mr. Denlocker, I see that you used an email address to serve him copies of those documents. The question I have for you, is there an order or an agreement, an agreed order that allows service via email?
Yes, there was in the past, because after he had moved from his mother's house, he had wanted me to serve him through email instead of in person, and I don't even have his new current address to be able to serve him in person. So, and I also serve him weekly with my UAs through email.
Okay, so you mentioned that there was a prior agreed order or an order. Can you give me a time frame of when that order was entered? Because I was looking at it, I couldn't find one.
So I don't know if there was an actual order. I think it was in our paperwork. It was like an option when he had filed paperwork where you would mark that you agreed to be served by email.
Yeah,
I
can you
believe
give
that's
me
where it was
approximate
at.
time frame? Approximate time frame?
So that would have, I believe it would have been in the paperwork he filed, either the end of November or it was possibly the one that we had went into. I think it was the end of December or maybe beginning of January. But when he originally, I just don't remember if it was when he originally filed in November that he had marked that or if it was a later date. Because he moved out of his mom's house the end of December. I know that. And it was after that point that I didn't have a current address for him. But he had like marked that I could serve him by email. And then when he came to pick Emma up a couple weeks ago, I had confirmed in person that he had received the email because he wasn't responding back to me. And he said, yes, I received it. I haven't had time to really look at it yet because I have to do it on a computer. And I asked him if he would like a copy, a paper copy of it. And he said yes. So I also gave him a paper copy of everything. But I know I'm not supposed to serve him myself in person. So I just made sure that he had confirmed that he received the email as far as proof of service. And then I did also give him the copy, like I said, of everything in paper form.
Okay, thank you, Ms. Lucor. So the clerk helpfully pointed out in his response to the petition filed on January 19th, 2024, on the last page, he declares under penalty that the foregoing was true, and he's attached that, and he signed it, and then he says, I agree to accept legal papers for this case at a particular email address, and then I'll double check to see, make sure that's the same. It is. This is so it looks like email, the service was proper. And so there's a parenting plan. And have you heard from Mr. Denlock or Ms. Lucor?
Not today. I looked on to see if he was present, and I saw that he wasn't on there. So I sent him a message asking if he was going to be logging on to the Zoom call, and I haven't heard anything back from him. So I haven't spoke to him since last Saturday when he picked Emmeline up.
Any indication that he was planning to be here or not planning to be here?
No, not specifically. The only thing he said to me about it at all was just that he felt like my request was unrealistic. But that was weeks ago that he said that, so.
Okay, all right. Give me just one moment.
Okay.
First item is your motion to appoint a guardian ad litem. Based on the service via email, I'll grant that order. We take appoint guardians ad litem on a rotating basis. And so we take the next 3 individuals who are on the list, and each party can strike an individual that's on that 3 list. And then we end up with 1, or if there's no strikes, then we end up with the person who's on the top. So I'm going to ask our clerk to tell me read the names into the record of the 3 individuals who are next on that list.
Amy Turnbull, Beth Fellows, Heather Call.
Any of those 3 individuals, Ms. Lucor, that you would like to strike?
The first one, I would like to, sorry.
So if you strike
yeah,
the first one, then the next person would be Beth Fellows.
Yes.
Okay, so I'll appoint Beth Fellows. As guardian ad litem, and so I've signed off on your proposed order. The next issue is the parenting plan that was submitted for review and discussion today. I'm a little more hesitant on that because as a general rule, service needs to be done either in person or through mail or some of the more traditional ways. And then there needs to be an agreement for for serving via email, which he specifically said, I agree to service. And then there's an affidavit of mailing that you use that same email address that he agreed to receive service. And so that was done on May 17th, giving him notice of today's hearing about your motion, the proposed parenting plan, the guardian ad litem, and the like. I'm a little hesitant to sign off on that, but he was given notice, so I'll sign off on that.
May I ask a question really quick?
Sure.
So I did fill out the paperwork as far as the fee waiver for the guardian ad litem. I was told to wait to turn that in until it was decided. So would I just now that you did appoint a guardian ad litem, now would I go in and just turn in that paperwork?
On the guardian ad litem order, I said it was going to be what we call a county pay case. In other words, the county pays the guardian ad litem for their services.
Oh, okay. Okay, so
So
I won't need to turn that in then.
No, I
Okay.
don't think so. No.
Okay.
All right, so I've signed off on the parenting plan. You can get a copy of that order from the clerk's office in a couple days.
Okay. And that,
Okay.
when does that go into effect?
I signed it at effective today.
Oh, okay. So I guess as far as I had requested rotating weeks. So I guess if it starts today, then would my time with her start on Friday then? Is that, I think that was how I had stated it. Like, I guess I just am not sure, like, as far as when it starts, would my week starting on Friday? Or would it be like,
Yeah, I don't think you
sorry,
specified in the order, you just indicated it'd be alternating weeks starting
Okay.
on Fridays. So if who's the child with currently?
Ryan?
Okay. So then if it's with him now, then that would be kind of an understood that he has custody now, and then the alternating week would start on the Friday as indicated by the order.
Okay. And then I did have one more question. So I had mentioned that he's in the middle of a DUI case in Clark County, and he is scheduled to have trial for it's his third DUI. It's scheduled on June 13th. I had put the 16th, but I guess it's the 13th. I'm mainly just worried if he does get convicted of that and he's sentenced to jail, as far as that changing things. So I didn't know if we could maybe set up a review, or if I would need to file for that, or how that works. Just like if he does end up getting convicted of that and he is sentenced to jail, then how do I go about that? Or are we able just to set up a review like right after his trial to review that?
Is your concern that he'd be incarcerated and unable to care for the child?
Yes.
So if he's unable to care for the child, then obviously that you would be the parent charged with caring for the child while he's incapacitated.
Okay. Okay.
So I
I
don't
just
think there
wanted to
needs
make
to be a
sure that.
separate order. Yeah.
Okay. All right. Thank
Okay.
you.
All right, very good. That'll conclude the matter for today. Thank you.
Thank you.
Your Honor, I apologize.
Ms. Looney.
Again. If we could take, I believe it's still number 4 on your docket. If the parties are present, Denlocker and Lucor.
Yes, Ryan Denlocker and Heather Lucor, 233-00494-08 is the cause number. And we'll ask if Ryan Denlocker is on the line today. Ryan Denlocker. All right, Mr. Denlocker, if you're there, please make sure you're unmuted and state your name, please. All right, not hearing a response from Mr. Denlocker, I'll ask if Heather Lucor is on the line. Ms. Lucor? All right, not hearing from Ms. Lucor either.
Your Honor, the case was on today on Ms. Lucor's motion. So if neither party is present, the state would just ask to strike today.
Yeah, it is Ms. Lucor's motion to modify child support. It looks like Mr. Denlocker was not served, and I didn't see proof of service on the state, but I did know that you filed an objection. So I'll strike today's hearing.
Thank you, Your Honor.
Your Honor.
Yes.
I'm sorry. This is Heather Lucor. I had gotten on here late and I apologize for that. My daughter was up all night throwing up and I ended up falling back asleep this morning. It would have been with me and Ryan Denlocker. It was for child support. Do I need to just check in with the courthouse to find out what happened with that, or did it get pushed out?
Yeah, I can tell you what happened. Sorry to hear your child's not feeling well. Hopefully that they feel better soon. Sorry to hear that.
Yeah, thank you. I apologize.
So I did call your case earlier. The Ms. Looney on behalf of the state or the Division of Child Support was present. Either she or Ms. Russell, I think it was Ms. Looney. She was present. And when I called out names, Mr. Denlocker didn't respond. He wasn't here. You weren't here. And so then I indicated that I didn't see service of your motion on Mr. Denlocker, and I didn't see a declaration of service upon the state, although they apparently got service and they filed an objection. So basically what I did, I just struck the hearing. I struck the hearing, and so it could be renoted for a future date.
Okay.
Declarations of service have been filed.
Yeah, I did file it. I honestly had forgot to file it earlier. So I had filed the service yesterday, and and I had them give you, well, they were supposed to give you a bench copy of the service, but yeah.
They did give me a copy of it. And I failed to mention that too, so I apologize for that. So, and at the time of the hearing, I didn't look at that. I didn't look at that bench copy because it was just handed to me just as I was going on the bench. So for clarification, you're absolutely right. It was filed. You're right.
Okay. So I just need to file for a new court date. Do I have to file like all the paperwork again, or will that paperwork apply if I just file for a new court date?
Yeah, anything that you filed stays filed, and you
Okay.
can just set a new court date and give notice to the other side.
Okay. All right. And then
All sides,
I
including
will
the
give
state.
notice to the prosecutor office
Correct.
also. Okay.
Yep, that's
Okay.
right.
Thank you.
All righty. Thank you very much. All right. With that, we'll go ahead and end the docket and the Zoom call.
Then there was another hearing with them scheduled a month later that was also stricken during court. The reason for striking the hearing seems to be that they both chose to appear by Zoom without getting permission from the court ahead of time. But whatever the actual reason, that hearing was struck. More than 3 months later, there was a new motion filed that proposes changes to the child support and parenting plan. That motion is scheduled to be heard on March 31st, and we can see from Odyssey that there was also a motion for show cause or contempt that will be heard at the same time as the proposed child support and parenting plan changes. Unfortunately, we won't be able to see those hearings, and the information that they use to update Odyssey is very limited. I'll keep an eye on it to see if we can figure out what's going on, but I wouldn't get my hopes up. It seems like these two are back at it again, and it's only their daughter who's going to suffer. Thank you for watching. See you next time.